Hello and good afternoon, or good morning, depending on where you are. My name is Preston Bryant with McGuire Woods Consulting, and I'm joined by Brennan Keene and Ann Neal Cosby with the McGuire Woods Law Firm. McGuire Woods Consulting is affiliated with the McGuire Woods Law Firm. I represent many energy interests before the Virginia General Assembly on energy and environmental policy, and I also do permitting and regulatory advising on solar and other renewable energy projects. Brennan Keene and Ann Neal Cosby, both lawyers, work in the land use and real estate section, and they do a lot of environmental projects and renewable energy projects. We are in Richmond, Virginia. This webinar is about changes in the Virginia renewable energy landscape, including major new policy changes from this year and which will be going into effect soon. Our representative practices, however, are nationwide. McGuire Woods and McGuire Woods Consulting have about 25 offices across the country. We are pleased to welcome more than 180 people to this webinar, and you are from across the United States. So there we are on screen, and I will go to what we'll cover today. Again, this overview is of the Virginia political changes that largely have led to Virginia's change in energy policy, most recently embodied in the Virginia Clean Economy Act. We'll briefly go over the Act's major elements, and we'll note the challenges or the big lifts that the Act calls for if it is to be successfully implemented. And we'll go over a lot of other legislative changes from this year's General Assembly, which may affect how you plan, develop, and execute your projects. Again, as there are more than 180 people on this call, many of whom are from outside of Virginia, we thought it'd be necessary just to set the stage a little bit and explain the politics and the policy changes that are impacting Virginia's energy landscape. Governor Northam was elected in 2017. He is a Democrat. And during the 2017 elections, there also was erased a very heavy Republican majority in the House of Delegates, bringing it to near parity. There are 100 members in the House, and now in 2017, it was reduced to 51 Republicans and 49 Democrats. That set the stage in 2019 when the entire legislature was up for election, and the House and the Senate both flipped to Republican. In the House, it is a very heavy Democratic majority. In the Senate, it is a slim majority. But in the Senate, on key committees, especially the committees dealing with energy policy, there's a very lopsided Democratic majority. So politically and structurally, the stage was set in 2020 for pretty dramatic renewable energy legislation to be passed. Delegate Rip Sullivan of Arlington and Senator Jennifer McClellan of Richmond were the patrons of the Virginia Clean Economy Act. It's a very big and complex piece of legislation, and it built on the Grid Transformation Security Act that was passed 2 years ago, which set new investments for Dominion and Appalachian Power in the grid, investments in the grid to modernize the grid and to make it more reliable. And the GTSA also set new renewable energy megawatt targets for the utilities. This past summer, Governor Northam issued Executive Order 43, which set a declaration that Virginia's intent to be 30% renewable by 2030 and 100% emissions-free by 2050. And so the Virginia Clean Economy Act gave kind of legislative voice to Executive Order 43. These are the main parts of the Virginia Clean Economy Act. I noted that it is a very complex piece of legislation. It was probably the most complex bill of the 2020 session. And of these elements, we will focus on the one that's labeled renewable generation, and particularly we will focus on utility scale solar. The Clean Economy Act, this is how solar plays into the overall march toward 2050's carbon-free grid. As carbon plants are closed, renewable energy is to be ramped up. The legislation lays out a year-by-year table. There's a table in the bill itself in the Code of Virginia now that sets the RPS ramp up, and it does so by percentage of total electricity sold. And it sets a step up, year-by-year step up for Dominion, and it sets a year step up by Appalachian Power. Over the next 15 years, you'll see that more than 16,000 megawatts of solar and onshore wind, to be sure, predominantly solar, has to be developed, and that's enough to power more than 3 million homes. And this 16,000 megawatt target, as you will see here, falls predominantly to Dominion Energy. And these are some of the milestone years set forth in the legislation by which Dominion and also Appalachian Power must step up their RPS targets. So over the next 15 years, or starting in just 4 years, starting in 2025, Dominion in particular must be generating 75% of their RECs from within Virginia, not wheeled in from outside, but generating it from within Virginia. So there is a lot to do in a very short order. This means also that there's a lot to do with local governments, especially on site selection for utility-scale solar projects. In Virginia, historically, and we'll talk about this more, local land use decisions have been just that, local land use decisions. So we can envision, with the intensity of ramp-up and the RPS in a fairly short order, we can envision an intensity of effort from many developers to develop tens of thousands of acres of utility-scale solar. And such will not be without controversy, and we will talk about more of this in this webinar. So what are some of the things that kind of just dynamically must happen? So the effort to develop this much solar in a relatively short period of time will require a lot of work by a lot of sectors. There is going to have to be a public education campaign of sorts about renewable energy, what it is, why such a big change, and what it means and what it entails. Virginians, like Americans, generally understand at a high level what renewable energy is, but when there's such a dramatic change in such a short period of time, it's logically going to cause questions. As I mentioned, in Virginia, land use decisions have historically been left to the local governments, meaning the state hasn't used but so heavy a hand to dictate how local land use decisions are carried out. But we can see, we can potentially envision that as developers launch their efforts to meet the goals of the renewable energy portfolio standard that has to be enacted, there may be some controversies as with local governments. And again, we'll talk about more of that, mostly around land use. Utilities obviously have a close relationship with their customers, and therefore they have a unique ability to strategically communicate with them. So utilities likely will have to step up their abilities to educate the public on why renewables and why now. Solar developers are in a unique position to see before anyone else where the on-the-ground obstacles are as they are reasonably trying to develop their projects. Developers are going to be kind of the canaries who can most immediately spot and communicate what's working and what's not. So they should step up as well. And then the state will have a role in helping to promote a workforce development for the solar industry, principally with the Virginia Community College system, in terms of both construction and technical training. And that can also be a partnership between industry and the Commonwealth of Virginia. The Virginia Clean Economy Act, at present, for those of us who have been practicing in Virginia and developing projects, we are aware of the sometimes push-pull relationship with localities on solar projects, and that's not unique. We obviously see that across the country with land use issues and with tax and revenue issues as well. The rural landscape may be changing. Financial incentives historically have been perhaps less than what localities have wanted, especially if under the current law, they have only been able to levy machinery and tools taxes on, for example, $20 million of a $100 million project. So there have been some financial disincentives for them to approve numerous projects. While developers may have wanted to step up and meet localities for an agreeable or more equitable compromise or tax and revenue relationship, sometimes Virginia law has limited what they could actually broker, and we will talk more about that as well, since Virginia is a Dillon rule state. So those developer versus local government dynamics are what have led the industry to want to see legislative changes to make an agreeable partnership with localities more possible. That is what set up the 2020 General Assembly session, the Virginia Clean Economy Act, and a host of other bills that were passed to make renewable energy projects hopefully more possible. So the Virginia Clean Economy Act and other changes in Virginia law will become effective in just over 4 weeks from now. They become law on July 1. So from here, again, this is Preston Bryant with McGuire Woods Consulting. From here, I will turn it over to Brennan Keene and Ann Neal Cosby of the McGuire Woods Law Firm.
Thank you, Preston. Very much appreciate the introduction, and thanks to everyone that's on the phone. And I wanted to add just a little bit of background on Preston, Ann Neal, and myself. Preston, through various roles, was very involved in following the Virginia Clean Economy Act and the other related legislation, and had a front row seat on what was going on at the General Assembly when that legislation went through the process. Ann Neal and I have a significant amount of experience in land use issues generally in Virginia, but in particular on renewable energy projects, primarily solar development, and have seen firsthand the challenges that developers experienced going through the land use process and some of the particular issues. And now we have a new set of tools that we'd like to discuss with you that the General Assembly has passed, and I think these are. This is going to be a sort of an interesting time for the solar development community as we work through how these new tools and opportunities help or create new issues for development. I think Preston's analogy of the development community being the canaries in the coal mine is an appropriate analogy. So without further ado, I'm going to hand it to Ann Neal. Ann Neal's going to walk through the legislation, the changes, and I'll provide some commentary as we go through. Ann Neal?
Thank you, Brennan, and thanks, Preston, and thanks, everybody, for joining us today. So I think Preston has the heavy lift of the Virginia Clean Economy Act. I think Brennan and I, our role is slightly different. There are various bills that we'll talk about today that were also enacted by the General Assembly in order to facilitate the Clean Economy Act. And I think Preston described sort of where we are in Virginia, sort of with this push-pull between localities and developers. And so we'll talk about the new tools in the toolbox. If you're from Virginia and you've been doing any type of zoning work, you are likely familiar with the Dillon rule, which is fairly unique in the United States. Only a few states follow the Dillon rule. If you're outside of Virginia, you likely have no idea what we're talking about. So every conversation that deals with legislative local government authority in Virginia starts with the Dillon Rule. And so that rule is essentially that local authority must be expressly granted by our state General Assembly. If it's not expressly granted, the locality does not have the authority to take a particular action. If it's not expressly provided, then it may be that a power is implied from or necessary to an express authority. But unless the General Assembly gives localities the power to do something, the power generally doesn't exist. And the Dillon Rule is important because in other states, if you're not from Virginia, usually the flip side is what's true in your state, that localities have express authority to take various actions unless it's expressly withheld or reserved by your state government. So that's why these new rules are so important for local governments, for developers coming to local governments, because we were very limited, again, with the tools in the toolbox and trying to really work within that framework in order to get these projects approved and moving forward. So with that understanding, we'll go through the different statutes that have been enacted. Preston spoke a little bit about the current M&T tax exemption. And again, that was, an incentive for solar development to get more renewable energy in the Commonwealth. And while that was very beneficial to the development community, as Preston said, it was really a financial disincentive for many localities that depended or had an expectation of significant M&T taxes, and then to have those reduced, or to 20%, and really no other, financial incentive for the locality to approve these, ever-growing, projects. And so the first thing that the General Assembly did was to acknowledge, well, is there a fix for at least, what we have on the books to date? So the first bill is that was approved. First of all, it extended the exemption. It was set to expire in 2024. Now it's been extended to 2030. It created a step down for that exemption. So while it still starts at 80%. Over 15 years, it goes, it steps down to 60%. So there was some benefit, some additional benefit that the locality could expect. So if the locality did nothing else, there was an assurance that there would be some additional money that would be available to the local government. There were some other technical changes as well, that the exemption would apply when the application is filed with the locality, as opposed to, I think previously it had been the date of construction. So some technical changes there. So this is sort of, step one. Can we make the M&T exemption a little bit better? So that was the first thing that came out from the General Assembly. Then they took a second step. Again, trying to realize that, again, are there ways to get additional monies into the revenues for the localities? So using their general powers to adopt ordinances, they were given specific authority to adopt an energy revenue share ordinance at their option. And so that ordinance allows the assessment of a revenue share up to $1,400 per megawatt per year. It applies to solar projects greater than 5 megawatts. And so it's available to the locality, but if they adopt this ordinance, then the developer is entitled to 100% of that M&T tax. So you don't get both. You don't get the 20% of the M&T tax, under the current law, even as amended. You can get one or the other. So I think what we're going to see are localities sort of doing that type of analysis internally. I think particularly for some localities, they've had several applications that have come by. They've seen some financial analysis provided as part of those applications. And so they're really going to take a deep dive and try to determine, what is best for the locality. whether it's the ordinance, revenue share ordinance, or whether it's not.
Yeah. Hey, Aniel, let me jump.
Yep,
let me jump in
ahead.
right there just to add a little commentary there. One thing to think about regarding the revenue share is that the revenue share is a flat number for the life of the project. So it's $400 per megawatt of nameplate capacity for the project for the life of the project. So for the locality, that is a steady revenue stream that they can count on. In Virginia, even though the locality's tax rate is applied to the project, the Virginia State Corporation Commission does the assessment of any facility. It's called a utility facility, public utility facility. And any solar project, 5 megawatts or bigger, is going to be deemed a public utility facility under the Virginia Code, regardless of the type of ownership. And so, since that assessment is done by the State Corporation Commission and it is subject to depreciation, the amount of tax revenue dwindles over time. What we've heard anecdotally is that some developers have looked at the numbers, and at $1,400 per megawatt, most projects already would pay more in year one under the revenue share ordinance versus the 80% abatement of the M&T tax, which then dwindles over time. So the locality that we believe most localities would be would find the revenue share attractive options. Thanks, Danielle.
Absolutely. For those of you who have projects that have been approved, I think the question, the initial question was, well, wait a minute, can this ordinance, this revenue share ordinance, if it's adopted, can that be applied to my project? And the answer is no. If so long as you had an application approved or filed before July 1st of 2020, when this legislation becomes effective, that your project is exempt from any revenue share ordinance that the locality may adopt after July 1st. Now, that being said, if there were a reason that a developer wanted to voluntarily, if there were some type of agreement that had already been negotiated, with the locality, and I know there have been some, in Virginia, notwithstanding the Dillon rule that made that very difficult without these new authorities. There are some, payment agreements that have, become effective. Can those be negotiated now? Yes, they can. And so the statute speaks to, if the current developer wants to, waive a portion of, their exemption and voluntarily make a payment, they can do that. They can revise their existing agreement. And if there's no agreement in place, the owner can agree to be subject to the revenue share ordinance. And again, that's going to depend on the facts of every project that's out there, how it was approved, what, the response has been in the locality, various other factors. So going forward, we think we're going to be seeing more of these revenue share ordinances for projects that have been approved. It's not an issue unless, there's a reason to sort of take another look at these types of ordinances. So moving on, we did see, I think Brennan and I, who have done zoning for, 20 years, we saw some new enabling legislation, come out of session that is fairly unique actually to, zoning and local government powers and, how business has been done, at least, for the past decades in Virginia. So the first of those are these siting agreements for solar projects in opportunity zones. And I'll take that sort of, I'll unpackage it a little bit. The siting agreement is just what it sounds like. It's an agreement between the developer and the locality. And as I said, there have been some developers and localities, who have negotiated, some types of agreements related to financial or other types of benefits that the developer, would provide to the locality. The sort of the sticky wicket there is there hasn't really been any express authority, as I mentioned before, under the Dillon rule that sort of allowed that to happen. So was it happening? Yes, it was in some instances. Where was the authority from the Virginia General Assembly for that? It wasn't expressly in the code. So I think that was sort of causing a hurdle for developers who wanted to provide these incentives, but where could they turn? And so I think the General Assembly smartly, sort of took what people were trying to do anyway and codified it. And so there is legislation that now allows a solar project developer to negotiate a siting agreement with a locality so long as the property is located in an opportunity zone. So what's an opportunity zone? It doesn't mean the same for the purposes of this legislation as it does for the purposes of larger opportunity zone tax benefits that some of you are aware of, where there are designated opportunity zones that get preferential tax treatment under the federal government. They're not the same types of opportunity zones. However, the state definition does borrow from that federal legislation. And so if a census tract has been designated by the state as being eligible, just eligible for consideration under the Tax Cuts and Job Act, then that's enough. So, don't get confused, or if you're looking online to see, hey, am I in an opportunity zone, you're going to see a very limited number of true opportunity zones in Virginia, very, very limited. But that's not what you're looking for. You're looking for opportunity zone eligible properties. And in Virginia, particularly in rural parts of Virginia, that's that's significant. And in fact, on this slide, you can see, if the eligibility requirement is based on census tract and really low income poverty levels. So you can see this map is available online. And so you can, that's the map you're going to want to look at to try to find if there's property in an opportunity zone that makes sense for your project. So how do you, what's the process for this? The developer gives the locality notice of its intent to develop a commercial solar energy generation or storage facility in an opportunity zone. And importantly, the locality must meet, discuss, and the statute says, and enter into negotiations for a siting agreement with the developer, which is huge because many times, as I'm sure many of you on the phone know, it's hard to even get the attention of the Board of Supervisors. But this is mandatory language that they have to meet with you and they have to talk to you. They don't have to agree on the agreement, but they do have to come to the table in good faith and talk about the project. So, what can you negotiate in a siting agreement? I would say really, and this is very unique in Virginia, we don't generally, we don't see this, that sort of the sky's the limit, or, the terms of the agreement don't have to be based on impacts caused by or even related to your project, which is normally, again, what we see, that there's always been a nexus between this is what, my project will, will impacts that might be caused, and here's what I'm willing to do in some way, whether that's improvements or cash to compensate. That's not what's necessary for a siting agreement. It can include terms and conditions for mitigation of impacts. And Brennan will talk about this, but trying to get everything in your siting agreement, is a strategy that probably makes a lot of sense. But the siting agreement can include terms related to the mitigation of impacts, but it can also include terms related to financial compensation to address the locality's capital needs. So that has nothing to do with your solar project. Those needs, can be set forth in their CIP, in the capital improvement plan, or in their budget, or in their funds balance policy. But again, these projects have nothing to do with your project, but you can agree, to provide some type of compensation for those, needs of these localities. Also huge is assistance with deploying broadband in the locality. And, that's always been an issue in Virginia. And particularly in rural localities. I think we're seeing that with COVID, with everybody, trying to live their life online, and, just the economic disparity we suspect that this, will show that, it will be huge going forward. So all of those are now opportunities for a developer to look and see, what does the locality need and what are they able, to offer. So, that again is new for us in Virginia. If the parties agree on the terms, again, coming back to process, the local governing body will hold a public hearing before approving the siting agreement, but there doesn't have to be a planning commission recommendation for this siting agreement. And we can talk about that, but for anybody that sort of has dealt with trying to get approvals, from local government, having public hearings, of course, before the planning commission, which is what's required in Virginia, and then having another public hearing for the board of supervisors, it's a big, heavy lift, too heavy lift. So at least for your siting agreement, if you can negotiate that with the board of supervisors and get everything, as packaged up as you can, you've really, pushed the project forward. The availability of the siting agreement doesn't mean, though, that you still don't need your special use permit or special exception or conditional use permit. Those are all the same thing in Virginia, by the way. Some localities kind of make a distinction, but legally speaking, whether it's called a CUP or a SUP, it's the same. And most, but not all, localities in Virginia now require some type of SUP or CUP for a utility scale solar project. So under this legislation, the developer would be negotiating a siting agreement and also then going through that zoning process. The good news is the siting agreement will control over inconsistent terms in an underlying zoning ordinance. And that's pretty huge here in Virginia too, because, typically, the zoning ordinance will always control. We don't have and can't have contract zoning, if you will, but in this legislation, the General Assembly is saying, hey, if you've negotiated this siting agreement on these terms, to the extent that, at the end of the day, there's something that's inconsistent in the zoning ordinance, we're going to let the siting agreement control. So that's something to think about and think about strategically, again, in those initial conversations with the Board of Supervisors. Just taking a look at the zoning ordinance and, is there anything that's in that ordinance that, is going to maybe be a difficulty for the project? And is there, is that something that you can sort of look at the front end and maybe address a little bit in the siting agreement? Another aspect of the siting agreement that's beneficial to your project is that if the siting agreement's approved, the solar facility is deemed to be, and I'm doing air quotes here, substantially in accord, end of air quotes, with the locality's comprehensive plan. And those of you who practice in Virginia, I think are getting used to this requirement. It's based on Virginia Code 15.2 2232. So sometimes we call it a 2232 review. Sometimes we call it just a substantially in accord review, or sometimes SIA. But basically, it requires that in addition to getting your CUP or SUP, there needs to be a separate action by the local planning commission, where the commission determines, not recommends to the board, but expressly determines that the location, character, and extent of the project is substantially in accord with the local comprehensive plan. So it's slightly nuanced, the determination that the Planning Commission is making, but it is a requirement. And if, you're going through this whole approval process, and if this 2232 review, isn't expressly made by the Planning Commission, and you get to the end and you've got your CUP and somebody says, oops, shoot, we still needed to get this, 2232, how do you address that? I think localities are understanding you really do need both, but it's, in so many projects, it just becomes an additional hurdle. And so I think the General Assembly smartly determined that, look, if you've got a siting agreement, then you don't need the 2232. So you can check that box. So again, that's another benefit of these siting agreements. Brennan, I don't know if you wanted to jump in here and talk about some of the, the issues related to these processes and criteria.
Sure. Yeah. This is because of the siting agreement legislation being unique, different from the sort of typical process that we've experienced in land use decisions, particularly on renewable energy projects. Looking at the timing of when you're going to have those conversations with the locality, when you're going to file your zoning case, which would have to be either concurrent with or after you give notice to the locality about the siting agreement, and understanding the context of the siting agreement with your zoning process at the same time. And what we're going to talk about in a little bit is about how some of the changes on the use permit process may impact your decision making on your siting agreement if you're pursuing the siting agreement. There's a lot to think about and to pre-plan before you even meet with the local government about what you're going to suggest that as terms for the siting agreement and for the zoning. So there really has to be a lot of coordination, and you have to think through who's your audience, what's the locality's experience in dealing with these particular issues, how are you going to pitch your siting agreement, how do you coordinate that zoning process, and you may, one school of thought is you may want to front load everything on your siting agreement, because if you don't get it approved, you pretty much know where your project's going to land. If you can't land the siting agreement terms, there's a pretty low chance that you're going to be able to get through the use permit process. Something also to kind of keep in mind when you're looking at both the siting agreement and the next thing we're going to talk about is these decisions by local governments are wholly legislative. It is very, very difficult to go into a court in Virginia to challenge a decision, either whether it be on the siting agreement or on the substantial accord determination or on a use permit, and get that decision overturned. There's a great deal of deference given to the locality in the land use context. To the best of my memory, the last time a Virginia Supreme Court approved or overturned a decision of a local government on a zoning action was in the early 80s. So the law is very well matured, and there's a lot of deference to the locality. So the siting agreement really becomes a very key part of the process for you to sort of focus on and plan how to roll out the entire project. If you get those terms set, you would presume that in the normal course of things, that if you have those terms set up and you've dealt with those issues in the siting agreement, the zoning process should go a little more smoothly. There are no guarantees, particularly in this realm, but it's something you really have to think very carefully about in terms of how you're going to roll out your whole proposal. Thanks, Anil.
Yep. All right. And sort of with all of that in mind, we're going to get to the last of these new tools in the toolbox, which if we haven't fried your brain speaking about zoning in Virginia and 2232s and now siting agreements, we're going to ratchet it up a notch. You're in the graduate level. We're going to talk to you about the new legislation that specifically addresses these special exception conditions. Again, special exception, CUP, whatever they're calling them. Just a little bit of background as to the way things were in Virginia until July 1st of 2020. A special exception or a CUP, is a permit upon which localities, can place conditions, to again mitigate or impose safeguards on externalities of the use. you know, again, whatever the impacts were, you know, the locality could impose those conditions. So, you know, if there was something about noise, you could limit noise. If it was going to be some type of a transportation issue, you would impose a condition and say, you cannot do this. You know, we'll approve your permit, but you cannot do this, 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 and this. Sometimes that list is very short. Sometimes that list is incredibly long. And with a utility scale solar project, sometimes it's pages and pages of conditions. And some of you, many of you, you know, may know exactly what I'm talking about. You know, now we're saying specific stormwater management and ENS and all that, even though it's also regulated by a state. It doesn't matter. Localities are getting very, very specific in these conditions. But again, they've always been, you know, something that had to be related to the project. And in Virginia, it hasn't been the payment of cash. You know, that wasn't something, you know, you couldn't say, well, you need to mitigate this, or you need to make a cash payment for this. In Virginia, we do have, if a project is being rezoned entirely from one zoning district to a different one, A1 to R2, a developer could voluntarily proffer to pay money, and they frequently did, and so you could, but the locality, that was always a voluntary, and I'm using air quotes again, but a developer could voluntarily give cash. But the conditions on the cup, that was a different side of the house, you know. You couldn't do cash, but you could impose them. So you had this voluntary cash proffer over on the one side, the rezoning, and then you had the non-cash conditions in the cup. So we're not talking about proffers. We're not talking about rezoning for most solar development. I think all of you out there, you know, you're seeing it's a cup and it's an SUP. What this new legislation does for the first time is that the locality can, and the language in the statute is grant a condition. That's what's on the slide before you. That includes the dedication of real property of substantial value or substantial cash payments for or construction of substantial public improvements. And also on this slide is the need for which is not generated solely by the granting of the permit, so long as it's reasonably related. This slide has so much new information for us. So, you know, to unpackage it, and I'll try to do so quickly so we can get to questions. But first, you know, the grant a condition is a tiny bit misleading, because again, while developers and localities negotiate these conditions, you know, of course it's not, it's ultimately conditions may be imposed on the developer. The developer, if they don't like the condition and can't negotiate something else, you know, their recourse is withdraw the application. So, you know, so that's something that, you know, we wanted you to realize with this legislation. Secondly, you know, so what can that condition be? Well, they can require the dedication of real property of substantial value or cash payments for construction of substantial public improvement. So again, you know, these are big, and they're not asks, they're conditions. And thirdly, the need for which is not generated solely by the granting of the special exception permit, so long as it's related. So that means not only can they impose upon the developer a condition to provide substantial cash or improvements, you know, for some, you know, offset or offsite improvement. It doesn't have to be your pro rata share. As long as that improvement is reasonably related to your project, you know, they can ask you for your share plus some. It doesn't have to be, you know, the ask doesn't have to be generated solely by your special exception permit. I will tell you that all of those criteria on this slide are different. We've not dealt with this in Virginia. And so while this is another tool that is probably one of the broadest tools, because particularly if you're not in an area where there's an opportunity zone, you know, if you are, you know, if you have a development project and it's not in an opportunity zone, but you can potentially negotiate conditions with the locality that allows substantial cash payments or improvements or whatever makes sense for you, for your project, you know, for your budget. But just be aware, again, that these are conditions that technically and legally speaking, can be imposed upon you as well. And so going back to what Brennan had said with our prior discussion on the, on these siting agreements, having everything buttoned up front, every ask, every condition, every financial incentive that you can and should be offering, to be negotiated up front if you can, if you're in a siting agreement type of situation because you're in an opportunity zone, all the better. Because, what you don't want is to have negotiated this agreement, and get to a public hearing and something happens and it goes a little bit south or sideways or off the rails because now somebody's decided, oh, wait, what about this over here? Do we need a condition to address this impact? And if it hasn't been fully addressed and now they're saying they're going to impose it upon you, to what extent do you go back to the drawing board? Will that happen? Go ahead.
Yeah, let me jump in there. And sometimes that could be unintentional. And I think that's why you're sort of going back to this idea of planning and being prepared with your entire case before you talk to the locality about the siting agreement. If you are doing your due diligence, getting your studies together, looking at how you're going to develop the project, and there is, say, for instance, an intersection of a road nearby that is substandard, and you haven't really identified what the issues are there, you negotiate your signing agreement, it's approved, then you go through your zoning process, and you get into that zoning process, and the application is sent to the Virginia Department of Transportation for comment, and they come back and say, you're going to have construction traffic issues related to that intersection because it is substandard. Then the locality is going to say, well, we didn't think about that with regard to when we were looking at the signing agreement. We may need this in addition to what we've already agreed to. And that may be merely process and it not an extra grab or anything like that. It's just something that wasn't known, which is why I think it's really incumbent upon the developer to be prepared as well as you can when you start that signing agreement to understand all the potential issues that could come up through the zoning process, like impacts of that type, or know that if you're not fully don't fully understand all those issues, that there may be additional asks when you get in the zoning process that you're going to need to react to.
Thank you. Yeah,
thanks, Amy.
That's exactly right. Yep. I think we talked about that prior slide, so we'll just move on so we can take questions. But again, and I think we've talked about, how to coordinate the siting agreement and the CUP conditions, and in this universe, what if you also have a revenue share ordinance? So again, to Brennan's point, it's being aware of all of the different, moving pieces of this, of how this new legislation, will come to pass. And, it's all brand new. So, it's something we're going to have to wait and see whether everybody, is able to use this new enabling legislation and move the goals of the Virginia Clean Economy Act forward. I think, sort of the question is, we're all very optimistic that this will be a good thing. What happens if not? And then we kind of get right back where we started from with Preston, and that y'all are the canaries in the coal mine. And so if after a while you see it still doesn't work, then what's the next legislative fix? Because, there's always, the General Assembly is trying to push this new policy forward. And if localities, are just still unwilling not, to utilize this legislation, what are next steps? And that will be our next webinar.
Yeah.
So I think we're at time for the presentation and we can take questions now.
Yeah. And I've got the Q&A up, and if folks on the call have questions, feel free to post them on the Q&A log, and we'll respond to them as they come up. I've got a couple to start with. And the first question is, are opportunity zones identified by each county or by the developer? Is there a central database for developers to go to identify those zones? Is it up to the developer to bring it to the county's attention? I think that's a really good question, and I don't think folks have really thought about that. We have access to that information in our office. And Neil posted a map that shows where most opportunity zones are in Virginia. Some localities will have information on their GIS as to where those opportunity zones may be, and others may not. It is really, though, incumbent upon the developer to identify the property and determine whether or not it qualifies as an opportunity zone under the legislation, and then to approach the county. The next question is, are there any benefits to developers regarding the adoption of the signing agreement? And I would say there are benefits with the signing agreement if you're in a location that has issues that you can deal with on a community level through the signing agreement that otherwise are not permitted to be dealt with through other avenues, vis-a-vis, for example, the special exception legislation, even as it's been changed. For example, you have a community next door that has the need for some renovations to an existing building that they're using as a community center. And that's not necessarily something that would definitely be in the county's capital improvement program. And the community center, it's really hard to think of a nexus between a solar project and a community center. So in a siting agreement, you could, if that's the one thing that gets the community support that you need, you can agree to provide those funds for that community center. That's one example. I think in every instance, when you're looking at your sites and looking at the locality, and which is why I really say there's a lot of homework that you need to do up front and be prepared and understand and have a significant amount of local knowledge of what's going on in that community. If you understand that background, you can identify issues that address concerns that the county has and the community within that siting agreement that can garner support for your project. All right. Are there any other questions from anyone on the phone? I don't believe that we have the ability for people to to jump in verbally, do we? I apologize to folks on the call. This is my first time using this platform. Well, we're available anytime for if you have a question, you want to give us a call. This is the type of work that Neil and I just love to do, and Preston has been very involved, and he loves to do, because we really think that this one, personally for us, we're really invested in the development of renewable energy in Virginia and across the country. So we have really we really value opportunities to talk about these issues and to help clients when it makes sense to pursue additional development. So I've got a few more questions. The question here is, who has the responsibility to determine what is reasonably related? Is it the county attorney? Does it differ county to county? And Neil, you want to take that one?
That's a great question.
Yeah.
That's, you know, it is subjective. It's absolutely subjective, and it's going to vary, yes, from county attorney to county attorney, and sometimes from board member if you're in a county, you know, and are under a board of supervisors, you know, how far they want to push the issue. And so, yes, it does vary. And as Brennan said, you know, once a legislative decision is made, so long as it is, air quote, fairly debatable, then the locality, you know, their position will be upheld. So if something is, if it's fairly debatable, that something would be reasonably related to a project, you know, it's for the locality to say. And so that's why it's a sort of a stunning sort of statute, you know, that we're dealing with, you know, particularly when, you know, it's dealing with cup conditions. You know, you're not voluntarily proffering these things. So that's a great question.
Yeah, and I'll just give a little bit of context on how different localities look at this. We have examples already, and that is in the proffered context. One example is we have in Virginia a concept called cash proffers for residential development, where localities go through a process of identifying what capital facilities they need and how each new residential unit adds to the needs for those capital facilities, and we'll put a number as to the impact of that unit on each of those different capital facilities needs. And how they come to that number differs from county to county, but in one example is, with regard to transportation, most counties will look at the transportation portion of that cash proffer on a transportation shed, and the transportation shed could be a relatively tight area of the county, or it could be the whole county. And the impact of the development in the eastern end of the county, that's 25 miles away from the western end of the county, that the cash proffers from that eastern end of the county can go to pay for what's in the western end because it's viewed as one transportation shed. Same thing would apply in this context. The locality is given a lot of deference as to what is reasonably related. It is subject to that fairly debatable test, and so there is a lot of discretion there. There's question about slides being available. Commonly, I believe those are going to be available. I'm pretty sure that they are after the presentation.
Yes.
All right, so we have, yeah, great. Thanks, Conley. All right, so Neil, here's the next question for you. Can the agreement undercut the ordinance, so it's less strict? And
yeah, you know, when I saw that, and that's what I was sort of alluding to, so, you know, somebody picked up on that. You know, I think the answer is yes. You know, I think that the language says what it says, you know, that if the siting agreement has terms that are inconsistent with the zoning ordinance, the agreement controls. Do I think that the General Assembly intended, you know, for localities to negotiate around, you know, their, you know, duly adopted zoning ordinances? You know, I don't know. So, I don't know that I would go into a locality and say, oh, yes, you are absolutely, you know, able to do this. But I think the effect is yes, you know. So I would say tread lightly, but I think the answer, is yes. Brennan, I mean, what do you do?
Yeah, I agree, and it's it is unusual. And so the one thing that I see as a classic example of something you may want to negotiate in a siting agreement that developers deal with all the time are decommissioning requirements and decommissioning surety requirements in particular that may be in an ordinance or may be in the condition of a use permit. That is something that you may want to work through. As that's one type of condition that's, you're in your site agreement, you say, look, we're a company that has a lot of financial backing, we're financially sound, you can trust that we're going to do the restoration, we have the ability to do it. Carrying this a surety every year is not necessary, and that might be something that you can negotiate. That gets out from under what an ordinance requirement might otherwise have. Another could be buffers and setbacks. And a lot of times buffer and setback requirements in ordinances are based upon a concept of a particular type of use that may not necessarily match with what the solar project's impacts will be. So that's another area where you may want to negotiate terms in the site agreement that are different than what the zoning ordinance otherwise requires.
Yeah, that's a great question.
And now the last question that I think we're going to be able to take, because we've run over a little bit. In your experience, what cannot be included in the agreement? Well, I think our experience here is limited to the non-solar context. Because this is brand new legislation and the first opportunity to do this, at least in terms of a fully enabled provision in the code. But in the economic development context, where we run into this type of thing all the time, and this is one thing I would say about the site agreement. The site agreement itself may be unique to this process, but the idea of doing agreements with localities for development, particularly related to economic development, is not. A site agreement is just another type of agreement, type of development agreement. It's just within a new context that we have with this new enabling legislation. But the types of things I think you would want to be careful about in doing an agreement with a locality is getting too far afield of some relationship to the project. And, one example I could see is that and this is more positional strategy standpoint rather than more legal, but you may want to shy away from agreeing to fund a pet project of a supervisor who's your sort of key vote, who's in a completely different part of the county, because it may be perceived that you're just buying a vote. And that may make your zoning process more difficult. I think you have to sort of be mindful of the community that you're in and how that community may react to some of the things that you offer up as part of the site agreement. Again, I think that goes back to the idea that you really need to be very intentional and prepared with your entire case before you even approach the locality about the site agreement. Again, we're available for our contact information was on the slides. The slides will be available, and feel free to reach out to Preston and Neil or me at any time. Really appreciate your time today, and hope that you've learned more than you knew before you came on the phone, and that this will be useful information for you. I hope everyone has a great day and has great success moving forward in developing new solar projects in Virginia. Thanks so much.